Thanks very much, Miriam. So my name is Mary Jane Wilson, and I'm a lawyer and a partner at the law firm of Wilson Rasmussen. So that's in Surrey, British Columbia, and but I deal with people all around the province and sometimes around the world because I deal with probate and estate administration as well. So I've been practicing in the area of real estate and estate planning and estate administration since 1987, so it's 30 plus years that I've been doing this, so I'm very experienced, and it's an area of practice that I really enjoy. I am the author of the British Columbia Probate Kit, so I don't know if any of you have seen that book, but it helps people probate their own estates. If it's very simple, you might be able to follow the book. If it's a little bit more complicated, then you might need to hire a lawyer like myself to help you out. And I was lucky to be the recipient of the Surrey Board of Trade Women in Business Award in the professional category in 2013. So I have a very busy, vibrant practice, and I'm here today to talk to you about wills and estate planning and wills and estate administration. So on the planning side, it's making wills, planning to die, so to speak, and on the other side, what happens after you've passed away and we have to go through the probate process. So that's the topic today. So the things that I'm going to be covering will be estate planning and also planning for incapacity, because we won't all die healthy and there may be a period of incapacity along the way before we die. So there's some planning tools to cover that off. So we're going to talk about wills, what happens if you don't have a will, probate, what is it, what's the cost of it, because a lot of people don't know what that's all about. We're going to talk about wills variation, who can vary a will, because it's very nice that we can make a will, but sometimes the court will come in and vary that. We're going to talk about enduring powers of attorney, representation agreements, and advance directives. So that's a lot of material to cover in sort of 35-40 minutes. So I'll do my best to cover all of that. And then, as Marian mentioned, we're going to hold questions probably at the end. And I really encourage questions. It makes the presentation far more interesting when we're talking about real questions that you may have. So that's sort of the overview of what I'm going to be talking about. And everything that we will speak about today is governed by the Wills, Estates and Succession Act. So that may not be important to you, but I live with this statute every day. We as lawyers call it WESA, and it came into force March 31st, 2014, so it's a relatively new statute, and we incorporated a lot of the succession planning statutes under this one statute called WESA. So I'll refer to it periodically, and it's very important, and it covers everything that we're going to talk about. Excuse me. So we're going to start with why should I make a will? And of course, most of you are going to know why to make a will, but I thought that it's important to highlight some of these things and to maybe move some of you to consider to revise your will or make your first will if you haven't. Some people procrastinate on this, and you know, it doesn't affect them until someone passes away in your family or something happens. You think, oh, that could be me, maybe I should plan. So why should you make a will? Of course, you decide who receives your estate. The government doesn't decide. The Wills and Estates Succession Act doesn't decide. You choose. So of course, that's a very important reason. You can choose really whoever you want to be your beneficiary. You can choose your spouse, your children, friends. You may want to have a charity included. So you choose. You may want to set up trusts for minor children. If you've got children that are under 19, maybe receiving the money at 19 isn't a really good idea. So you can actually defer that, and you can say perhaps they don't get it until half at 25 or the balance at 30. Or you may have a child that has some kind of a disability, and we want to set up some kind of a discretionary trust for that child. They may be receiving some kind of disability benefit from the government, and all of a sudden if you pass away and they receive a lump sum under the will, the government will say, well, you've got money under the will, so we're no longer going to be making that monthly payment to you anymore. So there's ways that we can benefit the children and receive the disability benefit and receive money from the estate. But you have to plan for that. You have to actually make a will for that to happen. Of course, beneficiaries will receive at 19 if there's no trust set up, and most 19-year-olds, if they received a large sum of money, might not spend it as wisely as others with more experience. So it's good to protect them and set up a trust for minor children. Appointing a guardian is, of course, a major reason to make a will, and sometimes that's the reason why people procrastinate in making a will. They don't know who's good enough to take care of their children. But if you don't choose someone, then WESA and the government is going to choose for you. So it's a good idea to just make that decision and make a will. Of course, appointing an executor, you can choose who's going to make all of this happen for you. So the executor is going to be in charge of the money and the guardian is in charge of the children. So you may have people in your family that may want to help you with that. It may be a good friend, a neighbor, a child, a spouse. But you also may want to consider a corporate executor. If your estate is a little bit more complicated, if you have family that's particularly busy, they're raising a young family, they don't want to take on this responsibility, you can hire someone like a trust company. If you deal with Royal Bank, you might choose Royal Trust. If you deal with Scotia, Scotia Trust. If you deal with a credit union, maybe it's Solus Trust. So there's lots of trust company options for you to select if you want to have a corporate executor. And you choose who will carry out the terms of your will, right? So it's you that chooses, you are in control. And of course, gifts to charities. Leaving a gift in your will can be an excellent way of supporting a cause that you care for and you want to leave a lasting legacy. So of course, Parkinson's Society British Columbia is hosting this webinar, and it may be a charity that you are very fond of and want to leave some kind of a legacy when you pass away. So there's many ways of doing this. You can do this by a cash bequest. You can do it with a residual gift. There's many ways of doing that. And not only does it feel good and you're going to make help support a cause, but you get certain tax benefits by doing that. So you can benefit from certain tax minimization strategies. So that's sort of an added bonus when you're making a will, that you can save some tax and get more money to your beneficiaries. So what happens if you die without a will? So WESA governs this, and they're going to determine who gets what. And the public guardian and trustee is going to take care of the children's money if they're under 19, if there's no surviving parent. And the superintendent of child welfare is going to be in charge of guardianship. So again, if you make a will, you're in control of these things, and it's not WESA that's going to decide what happens. So what happens if you die without a will depend on who is in your family. So it's not the same for everyone. So if you only have a spouse, then everything will go to your spouse. So maybe that's what you want, and maybe you want to die without a will. So that's your prerogative. But if you have a spouse and you have children, it will depend on whether you have children in common. So if you and your spouse have the same children and you die, then your spouse will receive the first $300,000. If you have a child from a previous relationship and you have a child with your current spouse, then the spouse is going to receive $150,000 rather than the $300,000. So it depends on who's in your family, whether you have children that are in common, whether the spouse is going to receive $300,000 or $150,000. So this has changed by WESA in 2014. It used to be the first $65,000. So they've updated that, and it's a little bit more in keeping with what someone would need. $65,000 just really wouldn't be enough money anymore. So after the first $150,000 to $300,000, depending on whether you have children in common, then the estate is split in half. So half of it goes to the spouse, and the other half will go to your descendants. So your descendants will depend on who's in your family again, whether you have children, whether you have children that have passed away that have their own children, being your grandchildren. So a lot will depend on who your family is. Maybe you don't have child or grandchildren. And if the child is a minor, then of course we talked about the public guardian and trustee will hold the money for the child until they attain 19. So that's often people don't want to have the government holding money for their children. So if you have no spouse or children, then it's going to go to your parents. And if you have no parents, then it's going to your siblings, your brothers and sisters. And then it keeps going until we have the 4th degree of relationship. And after the 4th degree of relationship, then it will go to the government. So if you have no spouse, no kids, no parents, no brothers and sisters, no nieces and nephews, then the government is going to take over. And that was another major change in 2014 when we had WESA, is before that, they would keep going and try and find, 4th cousin, 5th time removed, and it would be somewhere, somewhere far away, and we didn't know these people at all. So the government decided, no, we're not going to try and search for these people anymore. It's going to be 4th degree, and then thank you very much, we're going to receive the money. So again, if you don't like that, you can make a will, and you can choose who receives what when you die. So there are certain formalities when you make a will, so you have to do it right in order for it to be effective. So there are certain rules, and again, they're covered by the Wills, Estates and Succession Act. So it has to be in writing. So, we're here on a webinar, and you may like that technology, and you may want to do a videotape of yourself and say this is who's going to receive everything from your estate when you die, and that's not effective in British Columbia. It has to be in writing. So you have to make sure that you write it down. It's got to be signed by you at the end. So sometimes they'll refer to a testator. That's the person that makes a will. WESA refers to a testator as a will maker, someone who's making the will. So it's got to be signed at the end by the will maker, and it has to be dated. So we want to know when you did this, because there may be several wills that you've made during your lifetime, and the most recent one will revoke the one that you've made prior to that. And it's got to be signed in the presence of 2 witnesses at the same time and in each other's and the will maker's presence. So it has to have everybody in the room at the same time watching you sign. So a lot of people make a mistake when they're doing their own wills and without professional advice, and they don't have it properly witnessed. There's lots of rules. It's got to be initialed on each page. While that's not a formal requirement, that's just really good practice, because we don't want anyone substituting a page and making themselves beneficiary, and you've signed it at the end. So initial each page. The witness mustn't be a beneficiary or a spouse of a beneficiary. So a lot of people don't know that either. And I had a situation a number of years ago where I was probating a will, and the woman had passed away. She had made a will. It was a homemade will kit. She had 3 witnesses. Very interesting. We only need 2 here in British Columbia. I think in Florida you need 3. So it must have been a Florida precedent or from some other area in the world that required 3 witnesses. So the son sort of organized this whole thing, and they troop up to the hospital because Mom's in the hospital, and everyone's around Mom's bed, and they say, okay, Mom, you're going to sign it. And they kind of figured, oh, well, maybe the beneficiaries shouldn't sign it. So there were 4 kids, so beneficiaries don't sign, but the spouses of 2 of the beneficiaries were there. They thought, okay, well, we'll just get the spouses to sign. And then Mom passed away, and she had divided it equally between the kids, and you think that's all great. And the 2 witnesses, the spouse of the beneficiaries signed, and those gifts were found to be invalid. So that was not what was intended at all. They just didn't have any professional advice, and that was not the intended situation at all. So you want to have professional advice and make sure that that doesn't happen. Must be 16. So it used to be 19. You used to have to be an adult to make a will, but that's now changed to be 16. And you have to be, of course, of sound mind. So you have to have capacity. You have to understand what you're doing. You have to know who's in your family, what assets you have, who you have an obligation to provide for, those kinds of things. So we as lawyers, when we're doing wills, that's one of the major things we have to do, is to assess capacity and make sure that people know what they're doing and who they are benefiting and what they're doing, that they're making a will and who's going to get what and who's going to manage what when they've passed away. The will maker must be 16, but the witnesses have to be 19. So if a bunch of 16-year-olds are gathering and witnessing a will, that's not going to be effective because the witnesses have to be of legal age. And of course, you can't be under any duress or coercion or undue influence when you're making a will. And that's another major thing that we do when we're doing wills as professionals, as we would meet with the will maker by themselves. They may come in with a friend or a family member, and we have the family member, the child, sit outside in the waiting room. And sometimes they get a little bit ruffled about that, and they want to come in, and mom needs me, and I want to help out. But they have to appreciate that I have to meet with mom or dad by themselves and make sure that they haven't been unduly influenced or pressured. And so I'll meet with them by themselves, and I'll ask them all kinds of questions. I will ask them, are you doing this because someone has asked you to do this? I will ask them if they're doing this of their own free will, and ask them, are people saying that they're not going to let you see the grandkids if you don't make me the beneficiary, or they're not going to take you to the doctor, or they're not going to help you out grocery shopping if you don't make them the beneficiary. And of course, they're free to talk to me about that without any pressure from someone sitting next to them, kicking them under the table perhaps, and saying, look at mom, you better do it this way, or else this is going to happen. So that's a very important aspect of what I do, is to make sure people have capacity, they know what they're doing, they're of sound mind, and that they're not being unduly influenced or pressured to make a will in a particular way that doesn't really meet what they want to do. So do-it-yourself kits, they may be low cost, but people make mistakes with them all the time, and they do result in a higher cost later on. So I'm not a really big advocate of the will kit. I have published a probate kit that you can do to help you probate wills on the other side when you are helping someone after they've passed away to probate. But wills kits, they're just fraught with all kinds of issues. And as you know, as we just have gone through, all of the various formalities of making a will, people don't know all of the rules. And they may look at the kit and they may think they know, but they don't. And they don't follow everything to the letter. And you have to, if you're making a will, you really have to know what you're doing. So, you may want to do a will kit, but I don't recommend it. And also no professional advice given regarding assets that fall outside of the will, regarding probate fees, minimizing taxes, wills variation matters. It's not just the document. When you retain a lawyer, you get all kinds of estate planning advice surrounding the will. And we're going to talk a lot about the things that go in a will and outside of a will, and minimizing taxes as we go through the various slides. So having said all of that, with WESA, this is something that's new, the courts can correct deficiencies. So before 2014, if you made a mistake, we can't correct it. That was it. There was nothing we could do about that. With a family that had the 3 witnesses and the 2 children weren't taking their share in the will because it was done wrong, that was pre-WESA, and the family themselves agreed that that was what mom wanted, and they made arrangements amongst themselves to make it work. But if one of the kids said, no, you don't get because that was a mistake, that would have been too bad. And there's nothing the disappointed beneficiary would have been able to do. But now the courts can correct deficiencies. So if you made that mistake and one of the children was saying, no, I'm not going to allow that child to receive, the court can say, no, that was just a mistake. The intention of the will maker was really to benefit 4 ways. So we're going to change the will and we're going to make it become effective. So that's a very nice thing that we can do now, but it's very costly to go to court. So probably minimum $5,000 minimum to go to court to correct that deficiency. So while you may have saved some money in making the will and getting that wills kit, you had to spend a lot more money on the other side. So I'll just tell you just generally about costs of wills, because people ask me about that. And this is just my practice, and I have a busy practice in a suburban area of the Metro Vancouver in Surrey. One will often is about $400. Husband and wife wills, because I just kind of flip the names. They're mirror images usually. It's another $50, so it's $450 for two, husband and wife, then to the kids, and then it's set up a trust kind of wills. And then if it's more complicated, if you have children that have disabilities and we're setting up a discretionary trust, if you are cutting people out of wills, we're dealing with more complicated matters, companies, different issues, then of course it gets more expensive as you add complication and layers of complication. So, wills generally speaking are not very expensive, and you get a lot of advice when you're doing them. So it's good to hire a professional. So recommendation, very biased, being a lawyer, of course. When making a will, it is always best to obtain legal advice. And especially if you're leaving a planned gift to a charity, it's even more important to obtain legal advice, because there are certain tax savings that we can look at, and we want to do it in a tax effective way so the beneficiaries get the most, the charity gets the benefit, and unfortunately for the government that they get the least amount. So what is probate? So we're kind of jumping around a little bit, but there's a lot of information that I think is important that everyone know. So this is now on the other side. We've been talking a lot about estate planning, before you die, what happens. Now we're talking about after you've passed away. So probate is basically the official proving that the will is valid. So that's all it is. And in BC, it's the Supreme Court of BC that grants probate if there is a will, and if there is no will, it's called an administration grant. So with a will, it's called probate; no probate, a grant of administration. In the olden days, before 2014, it was called letters probate, letters of administration, but there were never any letters. It was an actual court document. So they've don't use that old wording anymore. Sometimes old forms, you'll see letters probate, letters of administration, but now it's a grant of probate, grant of administration. And either of them are called an estate grant. So you may hear estate grant as well. So land title office, financial institutions, motor vehicle department, other places like that require this grant of probate. They don't want to take the chance that the will is not valid in some way, that it's not the last will, that there's a more recent will, that you didn't have capacity when you made it, that you were unduly influenced. They just want the Supreme Court to say that this is a good will, and then they're happy to deal with it. They just don't want to take any chances. It's all about risk. So if you go to the land title office and say, here's the will, I'm the executor, can you make me the owner of the property now? The land title office will send you away and say, please go to the Supreme Court and get probate. And then come back and we're happy to deal with you because we know that there's no risk to us, and the Supreme Court said that the will is valid. So that's all well and good, but the probate registry, the Supreme Court, doesn't do it for free. And everyone's very paranoid about probate fees, and they want to avoid probate fees at all costs, but they're really not as bad as some of the other things we're going to talk about with taxes. So probate fees they haven't changed, I think, in the 30 years that I've been practicing, so they may be due for an increase sometime in the relatively near future. We're going to be having a very large wealth transfer with the baby boomers getting older and passing on. And apparently there's trillions of dollars that are going to be passing to the next generation. So this is a way for the government to generate funds. So all estates over $25,000 must be probated. There are some exceptions. Sometimes if you have one asset, you are dealing with TD Bank, and it's, I don't know, $30,000. You've got a really good relationship with your banker there. they'll say, you know, oh, that's a professionally drawn will. You've got the death certificate. I've been dealing with, you know, the deceased for, you know, ever. I know who the kids are. I know all about them. I'm willing to take that risk. I'm not going to make you probate the will. I'll just have you sign this letter of indemnity and away you go. And they're happy, you're happy, and everything's great. But if you don't have a will, if you don't, if your estate, you've got other assets, they'll say, no, we're not going to do it this way. You have to go get the probate. So the first 25 generally is 25,000. Then the next 25,000 is calculated at $6 per 1,000. So that's another 150 on top of the 200. And then over 50,000, it's 1.4%. So $14 on every 1,000. So if you had $1 million estate, it's about $14,000 in probate fees. So that's not great. We don't really want to pay that if we don't have to, but it's not, you know, 20% or 48% like some of the other taxes we're going to talk about. So those are probate fees, payable to the Minister of Finance, provincial. It's kind of like a provincial tax, but it's a fee. It's a probate fee. They don't call it a probate tax. So there's certain things that you can dispose of in your will, and there's certain things that you can't or don't. So for example, life insurance. If you have a designated beneficiary and you name your spouse as the beneficiary, then when you die, your spouse receives that life insurance policy, and that's the end of it. There's no will to look at. There's no probate to deal with. So that's very easy. Tax-free savings accounts. These accounts have come into existence in the last, 5 or 10 years or so. You can name a successor subscriber, a designated beneficiary, and again, you can name your spouse. You die, they file a death certificate at the bank, and that tax-free savings account belongs now to the designated beneficiary. No probate needed. We don't need to look at the will. Registered retirement savings plans, registered retirement income funds, RIFs and RSPs, you can name a beneficiary for those as well. And if you name your spouse as a beneficiary, there's certain tax benefits that you get for that. And you can hold property in joint tenancy. You can have your house, your condo, your bank accounts, your motor vehicles, everything can be held in joint tenancy. And when you die, you file a death certificate, and it becomes the joint tenant's property. They just remove your name from title, and that's the end of it. So most couples will have all of their affairs structured jointly. They will have their life insurance designated, their tax-free savings, their RIFs, RSPs, their home, their bank accounts, their motor vehicles, everything's joint. They pass away, we file a death certificate at all these places, and then that's the end of it. There's no probate, we don't look at the will. But if you don't have them designated and they're in one name only, then we have to go through that probate process. So you can own property jointly in two ways, and some people don't really understand this, so this is an important concept. You can hold them joint tenants or tenants in common, but they're both jointly owned. It could be 50-50, it could be a third each, it could be a quarter each if there's four. Just the magic of it, it has to be equal for joint tenancy. So if it's joint tenants, then on death, the property goes to the survivor by operation of law. File a death certificate, no problem. If it's tenants in common, or if it's in one name only, you will need to probate the will and or administer it if there is no will. So you might have a situation where you have a husband and wife, but it's a blended family, and they have children from previous relationships. And while they don't want the property, they can live together and the property is equal while they're alive. On one of their deaths, they may let the other person live there until they die, but on the second death, they want the property to go half to their family and half to their spouse's family. So you can do that by holding it tenants in common. Or you might have a business situation and you have a business partner, and when you die, you don't want your property to go to your business partner. You want it to go to your children and your spouse. So that would be held as tenants in common. Or you might have, at 99%, 1% owner. That would be a tenancy in common situation because it can't be joint tenants because it's not an equal interest. So I get a lot of questions. So it's husband to wife, and it's in joint tenancy. Husband dies, everything goes to the wife, and the wife says, oh, well, that was pretty easy. Maybe now I should put the property in joint tenancy with my children. And we can do that. That's not a problem. It's a fairly easy transfer to do. But there's a lot of risk involved in that. And I'm not a big advocate of that because there are risks. And if you're terminally ill, if you're really old, define really old, who knows what that is now, then maybe you want to put your children on title. But if you are not really old or not, you're not terminal, then your children own the property with you and you have risks. So they could potentially mortgage their part of the property. They wouldn't be going to a conventional lender to do that. They might have to go to a secondary lender, or they may have a gambling or an addiction that you don't know about. They may have judgments. They may not be paying a Revenue Canada debts. They may have matrimonial issues. So all of this kind of gets dragged into your property, and you may have saved 1.4% on death, and really you didn't save it. They did, because you're dead and you're not saving any money. You're just passing it on. So you have to really weigh that risk and determine whether that's something that you want to take on. So you want to talk to a legal advisor about that. You don't want to just jump in and say, okay, that was easy. I'm putting my property into joint tenancy with my kids because they'll get it when I die. Think about that seriously and weigh the risks. So death and taxes. So this is a really big deal. So we kind of talked about probate fees, which is kind of a tax, but they call it a fee. So deemed disposition on death is a really big one, and it's usually more than probate fees. So we have capital gains tax in Canada, and we're very fortunate that our principal residences are not, we don't pay tax on the capital gain. And with the values of the property, certainly in Metro Vancouver and elsewhere in the province, and we've seen significant gains from when you purchased it. And that's all tax-free. But if you have a revenue property or a recreational property, there is a very large latent tax bill that you're going to have to pay when you die. And you have to pay it on death, and it's deemed disposition. It's not that you actually have disposed of it and sold it or actually made a transfer. It's deemed to have been sold on death. So what they look at is what you purchased it for, and then they compare that value to what the value is on death, whether you sold it or not. So, for example, if you bought it for $100 and you sell it for, or it's worth $900 when you're dead, that's an $800,000 capital gain. Half of the gain is taxed at $400. So $400,000 is taxed times, let's say, 20%. So that's, I think, $80,000 tax on that you have to pay. And that's way more than 1.4%. So you just have to be aware of that. That's recreational property, that's revenue property. So, and some of these properties, if you're up at Whistler or things like that, you have to really think about that, because you know, your family may want to stay there and they like it and it's been a great family gathering, and now maybe they have to sell it to just pay the tax. So, you know, you may want to insure around that and deal with that, but at least know that there is that, that issue. Income tax on RSPs and RIFs if the beneficiary is not a spouse. So if the beneficiary is a spouse, then you can transfer it to them tax-free. It just rolls over to your spouse tax-free on death. But it does not roll over to anyone else tax-free. So if it does not roll over to spouse, then the tax must be paid, and it can be as much as 48%. So some of these RSPs, you know, $400,000, $800,000 in RSPs on the second of you to die, the government is going to take some of that money on your death. Of course, the idea of an RSP is that you put it in when you're making more money and you take it out when you're retired and you're making less. So that's fine while you're not working, but on death, again, deemed to have been sold, whether you sell it or not, and it's like you made $400,000 on the year of your death, and you have to pay that tax. Of course, we mentioned currently principal residents are exempt from capital gains tax, so that's awesome for us. And then something relatively new is now you need to disclose the sale of the principal residence on your tax return, and there's penalties for non-disclosure. So for years, forever, we could sell our principal residence and we don't have to disclose it on our tax return because there's no tax. But now they're wanting to collect that information. So they just want to know that you've sold it and there's no tax, but they are keeping records of that. So just note that that's something new in the last, I think, last budget or the last budget, maybe before that. So taxes, terrible, but we've got charitable tax receipts can reduce taxes. So this is something that we have that we can feel good and we can contribute to charities and we can save tax. And we know that there's some really big tax hits. So the maximum amount that qualifies for the charitable tax credit is higher in the year of death or a year immediately preceding than it is during your lifetime. So 100% of the net income can be claimed as donations versus 75%. So that's a significant increase. So if you want more information about leaving a gift in a charity in your will, you should contact the charity of your choice and they will be able to provide you with more information. So it can be, a little bit technical, so it's important that you receive advice on that. And I'm sure here at the Parkinson's, they can give you all kinds of information on that. And there's more, there's free publications are available explaining the rules for charitable tax credits from CRA Taxation Office. So, you can maximize for your beneficiaries and help charities as well and minimize taxes. So it all kind of works together. So wills variation. So this is something different again. And before WESA, before 2014, it was called the Wills Variation Act. Now that Wills Variation Act has been encompassed in Section 60 in WESA, and the courts have the power to vary a will. So it's all well and good now that we say that you can make a will and you can decide who gets what and you have complete control, but now the courts have the power to vary the will. So the will maker must make adequate provision for spouse and children. So that's what the statute says. It says adequate provision. And adequate provision is not defined anywhere in the statute, and adequate means fair. And fair doesn't necessarily mean equal. So you may have 3 children and you may decide that you want to give it a third each, or you may decide that you want to give more to one child and less to another. And in my practice, I'm pretty much doing that weekly, if not daily, where I am favoring children. And there's all kinds of reasons to do that, and we have to be fair about it. And so we talk about fairness. So it's not defined in any way. 180-day limitation period, so a very, very short limitation period to do this. And it is from the estate, the date the estate grant is issued. So it's not from the date of death, it's from the estate grant. And estate grants can take, 6 months to a year sometimes, or longer, depending on various situations. So 180-day limitation period. So if you were a disappointed beneficiary, you want to see a lawyer very quickly to make sure that you don't miss that limitation. So variation of wills, determining what is fair. It depends on the situation. Every family is a little bit different, but there's certain criteria that they're going to look at. So the size of the estate is important. Is it large? Is it medium? Is it small? It's a lot easier to vary a will and move money around if there's a lot more of it. If it's a smaller estate, then it's really hard to start moving some of that money. Relationship with the spouse or the children. So the only people that can contest are spouse and children. It's not anyone else, spouse and children. It's not your parents or your friends or your siblings. So a very limited class who can contest it on fairness. And it depends on the relationship. Is it good? Is it bad? Are you estranged? You haven't seen your son in 20 years. Do you have a terrible relationship? Is it a very good relationship? You have a better relationship with one child than the other. That's going to count. Need of the beneficiaries. Are they poor? Are they comfortable? Are they wealthy? So if it's a very large estate and one of your beneficiaries is really poor, it's going to be sort of easier to benefit that person, that poor person, than if there was not as much money. But sometimes that poor person might have a drug dependency and you have a bad relationship with them and you have taken them in and out of rehab and they just haven't sort of recovered, and enough is enough. And they say, no, if I give any more money to that child, they're going to buy drugs and they're going to basically overdose, and this is not what I want. So they treat them differently and they give them less. Or maybe we set up a trust for that child and they're not getting it immediately. So the courts will look at all of these situations. Money given during lifetime. Did we put a down payment for one child? Did we help someone in rehab? What is happening with the family? So they look at all of those things and then they determine what is fair. So when I'm cutting children out, as I said, as I do regularly, then I'm going to have my will maker do some kind of a letter that I keep with the will, and they're going to explain why they think it's fair. And I'm going to talk to them a little bit more about each of their kids and their spouse, and what is the relationship like, and what do they do for a living, and do they have kids, and do they make money, and are they poor, and do they own property? And I want to get a sort of a feel for the family, and then I'll kind of give you an idea, say, well, that's probably fair, or no, that's maybe a little light. You can still do whatever you want in your will, but it may be contested. And they say, oh, no, my children won't contest. This will be fine. But believe me, death and money, and people ask me, did people really contest? Yeah, they do. They do it all the time. So it kind of changes everything once you've passed away and there's, $100,000, $1 million sitting up for grabs and you're not getting it, then people are starting to contest. So variation is a very big thing. Of course, the courts are also going to consider your wishes, the expressed wishes that you've made in the will. It's your money. You've decided who's going to receive it, and any reasons why the will maker may have left behind as to why they think it's fair. So that's why I want you to do that letter and outline it, sign it, date it. We keep it with the will. We may never look at it if no one contests it, but at least you have something, some say. I have notes, and then the courts are going to look at all of that. If you don't have that, and then it's the children fighting, and he said, she said, and then it's going to be credibility, and it's a little harder if there's no evidence. So that's all about sort of wills. I'm going to talk briefly about planning for incapacity, because that's really part of the estate planning as well. So there's 3 documents that operate while you are alive. Of course, wills operate on death. So planning for incapacity, enduring powers of attorney. So that's usually about the money. Representation agreements are more about health care and who you appoint. Living wills, health care directives and advance directives is more kind of what you want done if something should happen. So more kind of the what. So those are kind of the 3 headings that I'm going to quickly talk about. Power of attorney. So it's a financial document. It's not to do with health care. It allows someone, and it can be more than one person, to take care of your financial affairs while you're alive. Take care of your financial affairs. Enduring, this means that it survives mental infirmity. So you can make just a regular power of attorney saying, I'm going to Hawaii for 2 weeks, my house is for sale, son, daughter, whoever. If an offer comes in, you can accept that offer. You have this power for a week or 2 while I'm away. That's a regular power of attorney. An enduring power of attorney says it survives my mental infirmity. If I become incapable, you can carry on with managing my affairs while I'm alive. That's the enduring part. And it does cease on death. Of course, the will takes effect after you've passed away. If you do not appoint an attorney under a power of attorney, then no one has the power to sign for you, not even your spouse, even if your property is held in joint tenancy, even if you've been married for 30, 40, 50 years. Doesn't matter. If you have a joint tenancy property, someone has a head injury, they're in a car accident, and now we need to sell the property, we need to remortgage the property, you cannot sign for them. If they're dead, you get the property because it's joint tenancy, you receive it, but on incapacity, you can't sign for them. So everybody needs a power of attorney. So if you don't have one, definitely talk to your lawyer about having a power of attorney. And of course, you're going to appoint someone you trust because they have great power to act for you while you can't act. It's also while you're alive. If you're out of town, you can still ask them and say, look, can you do this for me? But most importantly is the enduring part if you become incapable. Representation agreement is appointing a representative. It can be more than one person. With a power of attorney, of course, you're going to appoint more than one person as well. It's a healthcare document, not usually financial, although we can add some financial aspects to it. I like keeping them separate because if you're dealing with the bank or the land title office, they don't like sorting through all of the healthcare provisions just to get to the financial, so we keep them separate. Where and with whom you reside, your representative can decide whether you're going into care. Major or minor healthcare decisions, whether you're going to have surgery, anesthetic, go to the dentist, any of those kinds of healthcare matters, they can decide for you. In the absence of a representation agreement, there are alternate decision makers for healthcare. There are not for money, but there are for healthcare. First off, it's spouse, then it's adult children who rank equally. So if you don't like the alternate designated beneficiaries, then you want to make a representation agreement. If you have no spouse, you have many children, you have no children, you just want to formalize it, saying who it's going to be, then you want to make a representation agreement. But there are alternate decision makers if you don't. Living Will Healthcare Directive, Advanced Directive. So Living Will is kind of an American term. No heroic measures to keep you alive. So that's kind of the gist of it. It's an expression of your wish in writing that you want something to happen or not to happen. And the representative must follow it, right? So whoever your representative can say no blood products, medication administered to keep you comfortable even though that may hasten your death, those kinds of things. And there's a very good publication, Fraser Health and the various health authorities, Coastal Health around the province, they put out this publication, My Voice. It's often free. Sometimes they do charge for it, like $6 or $9 or something. But you can download it or look at it. The website I go to is fraserhealth.ca. Look under Advanced Care Planning Guide, and you can find this advanced directive there. So those are the things about planning. So now there may be some questions, and I do welcome questions. We've run out of some. I've went longer than I thought. So okay, so we've got a question here. If the property is titled to a child prior to death, does the death tax still apply? So now that was my situation. So if it's parent to two children and you hold it in joint tenancy, you file a death certificate and it goes to the child on death. So there is no probate fee for that. So that's a great pro. But the problem with that is if you transferred that property to your child 10 years ago and you transferred it and the property was worth $200,000, and now let's say it's worth $400,000, and now there's a $200,000 capital gain. So $100,000 for your capital gain is exempt because you live there. Their capital gain isn't exempt because they don't live there. Their $100,000 gain is half taxed, so $50,000 is taxed at 20%, and that's way more than any probate fee. So that wasn't very good planning. So, if you're going to do that, then you're going to want to make sure that you have a trust agreement set up and saying that it's was really only for estate planning purposes and it really didn't belong to the child and it really belonged to you. And so that's why I say don't do that unless you're terminally ill or really old, because there could be some capital gains issues with that. So hopefully that answered your question. Next question, can executors charge fees? And is there a limit? Yes. Executors are governed under the Trustee Act, not under WESA. The Trustee Act says that the maximum an executor can charge is 5% of the gross aggregate value of the estate. So 5% is the maximum. It has to be a pretty complicated estate to charge the maximum. 2 to 3% is not unusual. And it's 0.4% of assets under administration. So if you are dealing with the trust, you get 0.4% of that every year for handling that. So you are entitled, but it is a fee for doing work as a job. It's income. So you have to pay tax on that, and you have to disclose that under your taxes, under your tax return for that. Anything else? Any other questions out there? Okay, so any comment on using contingent beneficiaries for RSPs and RIFs? So I'm an advocate of that. So of course with an RSP and a RIF, my first preference, if this is your choice, is to give it to your spouse because it rolls over to spouse tax-free. And you can say, if my spouse dies, then I give it to my children or whoever, to a charity, possibly. And then you pay no probate fees on that because it falls outside of the estate. It is not part of your will. So that's good. You save the 1.4%, but you still have to pay the tax because it's deemed dispossession, and even if it goes to child or charity, you pay the tax on that coming into your estate. But it's good because you'll save the probate fees on the contingent designation. Next question. My son is not my husband's son. Can he contest? So the people that contest are spouses and children. Children include natural children or adopted children, not stepchildren. So if in this question you have adopted your husband's son, then he can contest because he is an adopted child. But let's say, for example, and this is always a big thing while people want to have advice on this, if you and your husband have everything joint and you die, no, your husband dies first and he gives everything to you, and then you decide you don't like your husband's son anymore and he doesn't have any contact with you, and you have children of your own, or you decide you want to give it to someone else because you haven't seen him in 20 years, he cannot contest your will unless you've adopted him. So when we have blended families like that, you definitely want to kind of look at some planning strategies, and maybe you absolutely trust one another and your husband dies and absolutely you love this son and he's not adopted, and of course he's going to get it 100%, great. But if you choose not to, he can't contest on fairness. If you have an alternate attorney, can any of them act under your power of attorney simultaneously? Okay, so power of attorney, again, while you're alive, you can appoint someone to act for you. You can have a number of people. It can be who must act together if you choose to have them act together. So then they all have to act. They all have to sign off. It can be who may act separately, and that could be either one of them. So the one in Vancouver signs because they're usually here, and the one in Kelowna will sign, if the one in Vancouver is on holidays in Hawaii and they're not around. So it can be either or must act together, so that you can choose. If it's together, it's a little bit more cumbersome, maybe a little bit more protection for you. If it's who may act separately, there can be potentially a conflict. One would say, well, I'm doing it this way, and the other says I'm doing it the other way, and then you have sort of an issue, and you may have to go to court to sort that out. But contingent is something different. So when you say alternate, I'm not a fan of what they call springing powers of attorney. So if so-and-so becomes mentally incapable, then you go to the next person. Because then how do you define mental incapacity? Is that because they say you are? Is it because you have to have a doctor, 2 doctors? What does mental incapacity encompass? What is it? So I usually have 2 separate powers of attorney, and have the second one understand that they will only come into play if the first one cannot, and that second person decides themselves. But if you have all of the criteria as to what non-capacity means and when they're going to step in, and you want that encompassed, and that can be quite expensive to do, we can do that for powers of attorney. Okay, we've got a couple more questions, so I have to be a little bit quicker, sorry. Being an executor and a beneficiary at the same time and being able to contest as executor. So yeah, if you're the executor and you're a beneficiary and you're not receiving as much as you'd like and you want to contest it, you have to renounce as the executor because you would be suing yourself. So yeah, you'd have to renounce. And you can't be both if you're going to sue yourself. You can be the executor and a beneficiary, no problem, but you can't contest if you're going to do that. How is a life income fund taxed? A life income fund, a LIF. I think a LIF is going to be pretty much like an RRSP. I think a life income fund, and I'm not an accountant, but I think it's like an RSP, but it's locked in, so you can't cash it in and whatnot, and you can name a beneficiary for it, so you can avoid probate fees probably on the first instance. But I think it's going to be, if it's not to spouse, it comes into your income like an RSP would, and you have to pay tax on it, and it adds to your income, and the higher it is, the higher the tax is going to be. But I would probably defer to an accountant for you to double check that. Last question, if a portion of an estate is willed to teenage grandchildren, did they too have to wait until 19 until receiving? Yes, they will not be able to have that money until 19, and depending on if there's a trustee in that, the trustee will hold it. If there is no trustee, then the public guardian and trustee will hold it for those teenage grandchildren until they're 19. You cannot receive money until you're 19. That's it. So thank you very much. Thanks for those excellent questions. I appreciate that. That makes it way more interesting for me. Hopefully that wasn't too much information and I didn't go too quickly. I guess that's it. Yes.